Good afternoon to all of you. We were delayed. Last class was dropped due to some unavoidable circumstances. We had already finished the High Court in the previous class and examined the various provisions of High Court. And we have shown also the number of judges and the number of judges sanctioned. There are permanent judges and additional judges. So as of now, 404 seats about are vacant. So judiciary suffers from inadequacy in the appointment. This is also a fault of judiciary or a loophole of judiciary. We have a very low ratio of population, low judge population ratio in India. But despite suffering from low judge population in India, we have, in addition to this problem, it is also seen that the number of sanctioned judges are not filled up in day by day. Even today, the sanctioned of judges in almost all high courts and almost in the Supreme Court of India, the sanctioned judge seat are not filled, are filled vacant. So this is a tragedy. This is one of the demerits of subordinate or judicial system. Okay, we have to highlight also that in our writing. We have to highlight also that, and according to Law Minister report on December 31st, 2021, the strength of judges, that is judge population ratio per million population. The judge population, that is per million population ratio, judge population ratio, according to Law Commission or Law Minister report in December 2021, it is 21 per 1 lakh, or that is 1 million population. It is very high in the developed countries. That can be also compared. So even we have a low judge population ratio. In addition to the problem, the non-appointment of sanctioned judges also aggravates the situation. Hence, you have to highlight the loophole of Indian judicial system in India. Okay. Now we shall move to the subordinate court. Let me give an idea about the subordinate courts. As you see, in the hierarchical system, the Supreme Court and High Courts, and there are subordinate courts at the district level. Subordinate courts can be divided. Subordinate courts are of three types. One is civil court, and your criminal court or session court. And there are also revenue court, and in metro cities you can find also the metropolitan courts. Civil court, district civil court, under it works the sub-judge court, and under sub-judge court there like the municip court, and in case of session judge also you can district session judge and chief judicial magistrate also work under it, magistrate. Then judicial magistrate first class, under it. Then in case of revenue courts, there is RDC, Revenue Divisional Commissioner, there is DC, District Collector, there is Tehsildar, and there is also RI. So these are the structure of subordinate courts in India. And apart from this traditional hierarchical system, there are also courts like family courts, fast track courts. We can also list them. Family courts also exist in various states, and there are fast track courts also. Fast track courts, and there are grammar and you can say there are local adults and tribunals. So justice is to be provided to people in due time and in due course. Unless justice is provided in due time and proper justice is provided in due time, it will be a negation of the constitution. It will be a negation of the constitution, and it will be much against the constitution also. So with a view to providing the judge population ratio, with a view to providing due justice in due time to the people, the government of India has established various parallel courts or various additional court judicial system in order to achieve the objectives. Despite all these steps taken by the government, there has been not a visible reduction in the number of cases. Still, lakhs of cases are pending in Supreme Court and High Courts and also in subordinate courts. That is to be also mentioned. Okay, but still, effort is on. So now we shall first move to the traditional system of courts, subordinate courts. First of all, you have to remember that they are called subordinate courts because they are directly put under the domain of the high courts, under the authority of the high courts. The high court is you say, like absolute authority in the management, in the organization functions, in determining the functions, privileges of the subordinate courts. So High Court is the primary authority or is the major authority, although it is approved by the governor, but it is the High Court which ultimately rules the roost in case of subordinate courts. In this sense, we call them subordinate because they are directly under the high courts. And subordinate courts are mentioned in the part 6 of Indian Constitution. Part 6 of Indian Constitution from Article 233 to 237, as you can see on the screen, 233 to 237. Okay. Then the strength, if you talk about strength of Supreme Court, the subordinate courts, the strength is decided by the state legislature, means the approval of the governor and in consultation with the high court of the state. So it differs from state to state. The composition, even the functions, mode of appointment, and other related aspects of subordinate courts vary from state to state to a little extent. So that is done. Then the qualification of the district judges. We are mentioning about the qualification of the district judges. In case of district judges, there are no such big qualification that he should be a citizen of India and should not be in the service of the union or states at the time of appointment. He must have been an advocate for not less than 7 years in any court. And another requirement is that he must be approved by the High Court, must be sanctioned by the High Court of the state. Otherwise, he or she cannot be appointed as the judge of a district court. So the qualification of the district judges are, you can categorize it that citizen of India, should not be in service of the union or state government and advocate for 7 years, and apart from that must be approved or granted by the High Court. by the High Court of the state. Otherwise, he cannot be appointed. And with regards to recommended by High Court, okay, with regards to other judges or other members of the judicial service, they come through recruitment examination conducted by the Odisha Public Service Commission. In case of Odisha, so the other members, you can take a note of that. The other members except other members, you can say except the district judges, except the district judges are recruited through a recruitment examination, conducted by the State Public Service Commission. In case of Odisha, it is Odisha Public Service Commission. In other state, they have their own public service commission. They conduct the cases, conduct the recruitment examination for the appointment of the other members. So in this case, their qualification is obviously bachelor in law, BLLB, and other recommendation, other qualification may be assigned by the government or by the OPSC or the State Public Service Commission with the prior sanction of the governor. So this is the qualification of judges and other members of the state subordinate judiciary. Then in case of appointment, as you can see on the screen, they are appointed by the governor. The district judges are appointed by the governor in consultation with the high courts. High court's opinion in this regard is paramount. Governor cannot ignore the opinion or the recommendations of the High Court in this regard. He is almost bound by the recommendation of the High Court, and the High Court, the governor appoints. Then other members are appointed by the governor also in consultation with PSC, because it conducts recruitment examinations from time to time, and also in consultation with the High Court. Other members like the OJS in Odisha, they are appointed through a recruitment written examination conducted by OPSC. Then High Court finally selects the candidates for the Odisha Judicial Service. So this is a kind of two types of arrangement in case of appointment. Under Article 233, it is mentioned the appointment of the judges. Okay, I have already made the table of hierarchy: civil court, session courts, and sub-judge court, and your municipal court, judicial magistrate. There are also revenue courts, metropolitan courts. Okay, then the district courts, jurisdiction. Let me tell you one thing, that the jurisdiction of almost the district courts are extensive in character, because it is the first court where people have an access to which people have an access. It is the nearest court to the people. So it enjoys extensive original and appellate jurisdiction in the matter. The district session court entertains all the cases. Session court, that is the criminal court, which deals with criminal matters. It enjoys the power to deal with all related any criminal matters, and it can award punishment or sentences of any character, of any nature. Okay, it can award punishment of any character. It has the power, it has the authority, and it can also award the capital punishment. But after awarding the death sentence, it must be approved by the state high court, otherwise it will not be activated. So it can award, no one can deny that, it can award the subordinate courts, the district session court award death sentence. But after it awards the death sentence, it is to be examined or is to be approved by the state high court concerned. Okay, that is also a power. So that is the session court, district session judge. When he acts in the capacity of a session court, he is called session judge. When he acts in the capacity of a civil judge court, then he called civil judge. So this is the things of difference between them. And district session court, as I told you, uses or enjoys extensive jurisdiction over the districts. It deals with all the criminal, it hears all the cases of related to criminal civil matters. It can award any punishment of any character. It can also award death penalty, death sentence, capital punishment to people. But such decisions, such award must be approved by the High Court. And coming down to Chief Judicial Magistrate is also the authority to award sentence up to 7 years imprisonment. It may vary from state to state or in other states. So they can award punishment of 7 years to up to 7 years maximum to the victim, and below him works district or first class judicial magistrate. He also has the authority to award sentences up to 3 years imprisonment. So these are the sequence or the hierarchy of the courts, and in case of civil court also there is a hierarchy, and the district civil court enjoys more extensive powers than the sub-judge court and municipal court. In case of district court, you have to, in case of district courts, you have to remember district civil courts that in case of district civil court, district civil judge can award pecuniary punishment by pecuniary sentence of any amount to a party. There is no limit. In case of district sub-judge court, it has a limit. The sub-judge court can award sentences up to, or that is of a fine, can impose fine up to 50,000. And in case of your municipal court, it awards punishment up to that punishment, that is fine up to 30,000. In Odisha, we are talking about, it may be different from state to state. As I told you, the structure, organization and nomenclature of the district civil courts vary from state to state sometimes. So these are the subordinate courts or courts, and their authority lies, and you know the jurisdiction of High Court. Under the jurisdiction of High Court, we had already discussed that the High Court has controlling authority over the subordinate courts. They can detect wrongs to them. Okay, and this is all about your district courts, the subordinate courts. Another court system is family court system that was established in 1984 under Family Court Act 1984. Family Court deals with powers related to family matters like divorce, marriage, land inheritance, and other disputes in the family can be resolved by the family courts. Many states, including India, including Odisha, have provided for your that is family courts. And family courts act as a grievance redressal authority with regards to your family disputes. Alright. So that was established in 1984. That is also a kind of thing you have to remember. And they deal with matrimonial cases and your matrimonial cases and that we are talking about family courts. They were established in 1984 under an act which provided establishment of family courts in several states. Odisha has got also certain number of family courts, and the characteristic of cases related to matrimonial matters, divorce matters, and land inheritance matters, or any dispute arising in a particular family. Okay, so Family Court 1984 provides for the establishment of family court by the state governments in consultation with high courts. It makes obligation by the state government is not a step. Family court in every city or town with a population exceeding 1 million. It makes it obligatory for state government to set up. Okay, that's a good point. The act, I'm reading out the act and we are examining the act also. So let me say that number 1 provides by state government in consultation with court. Provides for establishment of family court by state government in consultation with high court. Government in consultation with high court. This is the past features. I'm reading out the art itself. Number 2, it is obligatory for state government to establish family court every city or town with a population not exceeding 1 million. It also enables the state government to set up family courts anywhere they like. The Act also authorizes the state government to set up a family court wherever it feels that it deems necessary or it is necessary for that purpose. That can be also a cause. It exclusively provides within the jurisdiction of the family courts the matters relating to. What are the matters that are dealt with by the Family Court Act 1984? Matters under Family Court Act 1984. Family court under matters under family courts, that is under Act 1984, are matrimonial matters, or you can say including nullity of marriage or rejection of marriage, judicial separate divorce, the declaration to the validity of marriage or to the matrimonial status of any person. Then if the property of the spouses or either of them, it can also matrimonial cases related to divorce and others. Property related matters of the both spouses, both husband and wife. Property related matters. Then guardianship of a person or custody of any minor. You can say guardianship of minors, minor underage, that can also be assigned. Okay. Then maintenance of wife, children and parents. Maintenance of wife, children and maintenance of child, maintenance of the persons. Okay, that can be also a point. Maintenance of wife, children and parents. Parents of the conjugals. It makes obligatory on the part of the family court to endeavor in the first instance to effect a reconciliation of settlement between the parties. Family court is not as per the functions in accordance with the traditional courts. Rather, they are to some extent a different court system which they may try to resolve the case on conciliation. That is also a kind of alternative dispute redressal mechanism, conciliation. Conciliation is probably the two agreed parties appoint a conciliator to decide, and they are to abide by, but they are not bound to abide by that. Conciliation. So, family court deals with disputes or give emphasis on the given emphasis on these disputes also, and emphasis on the reconciliation settlement between the parties during this stage. Proceedings will be informal. It provides for association of social welfare agencies and your counselors during conditions of states. It provides for only one right of appeal which shall lie to the High Court. So appeal against family courts lie to the High Courts. This is all about your family courts. Then there is a concept of Loko Adalat also. We shall discuss the procedure of Loko Adalat. But Loko Adalat is a term that was there. Lok Adalat means a traditional court pattern. The Legal Services Authority Act 1987 authorized the establishment of Lok Adalat. Okay, it is an innovative mechanism for alternate dispute resolutions. I told you that alternate dispute resolution mechanism is in place. Its primary objective is to relax the burden on the courts. So therefore, Lok Adalat is one of them. And during the past several years of experience, we can say that family courts or permanent Lok Adalats are okay. That is the things. Further, the cases which are related to public utility. For example, Mahanadar Telecom Nigam Limited, Delhi Vidyut Board need to be consulted urgently so that people get justice. Petty cases which could not go in regular courts could build in the pre-litigation stage. There are certain cases which do not need the attention of the courts. In fact, they are petty cases. They are related to trivial matters, and they can be dealt with all these local adalats. Okay. The permanent local adalat shall consist of a chairman who has been a district judge or additional district judge or has held judicial office for higher than rank, and that of the district judge to offer persons having adequate experience in public life. So overall, you can also grasp that local adalats are parallel arrangements to deal with the number of growing cases. And every award maintained by the local adalat shall be binding on the parties. And shall be to a majority on all persons comes to the parliament. Shall be final, and according to all these parties have to every award made by the research. There is no appeal. But in case of family court, the only appeal lies to the high courts. Okay, that is called Lok Adalats, and first Lok Adalat was set off in you can say in 1971 in Maharashtra probably. So that was the case, and later Lok Adalat, and under the provision of the act, there is also for a provision for establishment of permanent councils. Now, the family courts is gone. Grama Nyayalaya are established under Grama Nyayalaya Act 2008 has been enacted to provide for the establishment of the Grama Nyayalaya at the grassroots levels purpose of providing access to justice to the citizen. Every parallel court arrangement has the one objective, just to enable people to have easy access to their justice, or are not denied to any citizen due to socio-economic disabilities. Okay, so the regions for establishment of Grama Nyayalayas are access to justice by the people regions. I'm just reading out the act. Access to justice by people, by the poor people, poor and disadvantaged. Section. Disadvantaged section of the society remains a worldwide problem. Despite several number of courts, even in developed countries, it is not filled up. And in our constitution, there is a Article 39A was added by 42nd Amendment Act, which provides for equal justice and free legal aid to the poor, with a view to realizing the dream, the vision for a justice, for facilitating justice delivery system, for facilitating justice for the poor, disadvantaged, needy, and the poor and exploited sections of the society. They do not have the financial and other capability to move to any court. So Lok Adalat plays a very vital role in signifying that. So today Lok Adalats are functioning through various mechanisms such as arbitration, conciliation and mediation. These measures required to be strengthened further. The Law Commission in its 114th report or Grammar has suggested establishment of Grammar as the speedy and expensive substantial court. So remember that is the Lok Adalats and Lok Adalats, that we are talking about Grammar. Sorry, we are talking about Grammar. They are established under Article 208 and this is also the logic also. Every subordinate judicial body has the same logic that to provide access to people to justice. So Grammar also is in the same light. It is access to justice by the poor and disadvantaged remains a worldwide problem. So it is our duty to provide justice to all, and 39A provides for equal justice and free legal aid to the poor. The government has various measures to strengthen judicial system like internal to simplifying the procedural law, incorporating various alternative dispute resolution mechanism and conducting of Lok Sabha, Lok Adalat. The measures are required to strengthen further. The Law Commission of India in 114th report of Grammar न्यायालय suggested establishment of Grammar so that speedy, inexpensive, substantial justice could be provided to the common man. Broadly, it takes to recommendation of the law commissions. Okay, so these are the importance of Grammar. Then you can also have a look at the act, salient feature of the act. The Grammar shall be court of judicial magistrate of the first class, and the presiding officer Nyadhikari shall be appointed by the government in consultation with high courts. The Grammar shall be established by a panchayat at intermediate level of a group of contiguous panchayats at immediate level in district, or where there is no panchayat at intermediate level in state, where a group of contiguous panchayats. That is called Grammar. The Nyadhikari who will preside over these Grammar are strictly judicial officers who will be drawing same salary services of the first class magistrate working under the high courts. That is Nyadhikari called, and he enjoys the status of a district judicial magistrate. The Grammar shall be more mobile court and shall exercise in powers of both criminal and civil courts. The seat of Grammar will be located at the headquarters of the intermediate panchayat. They will go to villages, work there and dispute on the cases. The Grammar shall try criminal cases, civil suits, claims, disputes which are specified in the past schedule. Okay, they also follow the special, and appeal lies to the Supreme Court. The Grammar shall not be bound by the rules of evidence provided by the Indian Evidence Act 1872. So these are the major judicial bodies, Grammar and others. Okay, and what I mean to say you that this question, this chapter doesn't have any question. We have separate questions for that purpose also. Let me just show it in on your screen. That is on our screen for discussion. Let me send the files to your screen. That is to ban. Okay. So that is your questions. Sorry. Just a minute. We shall be sending questions to your end. So just a minute. Okay. So this is a common question that can also be discussed. So you can see the screen on that matter also. Okay. Now we can discuss one by one questions. And what is the first question answers to your questions? Common High Court. Yes. So today it's 17th May. Okay. So 17th May. What is the first question answer? That is, Common High Court for two or more states of Union Territory may be established by? Yes, Parliament by law. A. Under a single integrated hierarchical judicial system, High Court in the states are on directly under? Okay. D. Supreme Court. Who decides the number of judges in High Court? President. These are very short, fast level questions. We shall bring different questions for your sake. Now, question number 4. Which of the following Union territories have high courts of their own? Delhi and Jammu and Kashmir. The Family Court of Redressal of Family Disputes was first enacted in 1984. That is B. Which of the following articles deals with tribunals? 323. A, B, both. If you talk about administrative tribunal, 323A. In other tribunals, that is worse. Yes. The question is, the answer will be D. Then the match the following: Madhya Pradesh and Bilaspur headquarters. Probably I have shared with you, and that is Jabalpur, Chhattisgarh, Bilaspur, Rajasthan, Jodhpur, and Kerala, Ernakulam. So 2143. Article what 214? Article 214. Article 214. Establishment of Common 214. High Court as a court of record, 222 transfer, 231 common. 4321. A separate High Court of Telangana came into existence on 1st January 2019. A. Which of the following correct chronological order of the High Courts? Bombay first, Odisha second, Tripura second, third, Tripura first. 1862, 1948, 1975, 2013. That means 1, 2, 3, 4. 1, 2, 3, 4. A. Which of the following High Court headquarters is located in the state capital? Rajasthan, Jodhpur, Manipur, Imphal, not located. Okay, not located. Rajasthan, Jodhpur. But it has its bench and in Jaipur, the capital. Okay, but all other have Madras, Chennai, Manipur, Imphal, Karnataka, Bengal. Okay. Which one the following correct regarding the appointment of the judges of High Court? They are appointed by the President, all right. President consult the governor of the state in the appointment is also right. The Chief Justice is consulted in their appointment. Obviously, they must be permanent resident. There is no requirement of residence. So that is D. Which of the following is not a common High Court in India? Punjab, common, Bombay, common, Allahabad High Court, not common. D. The district judges are appointed by the governor with the in consultation with the High Court. C. Who became the first Chief Justice of Telangana High Court? Tethali B. Radhakrishnan. Okay. The pension of the High Court judges are charged on the consolidated fund of the state, India, but their salary is charged on the consolidated fund of India. But pension is charged on the consolidated fund of the state consult. The salary and allowances of the Lokpal of India is equal to Chief Justice of India. That is an extra question. The Bombay High Court has a benches at the following extract. Pune. Who became the first woman Chief Justice of High Court in India? Leela Seth. Justice Leela Seth. Among the following is eligible for becoming a chairperson of National, former judge of Supreme Court or former Chief Justice? B. That has been amended. National Judicial Appointment Commission was established under Article 99th Amendment Act 2014. The provision National Judicial Appointment Commission was established under 99th Constitutional Amendment Act 2014. 2015, 24. Okay, and you know it was abolished in 4th Judge case. In 2015. 4th Judge case. 4th Judge case was related to abolition or declaration of National Judicial Appointment Commission by the Supreme Court. And it was to be a variegated body not exclusively manned by judicial authorities. It was established with a view to replacing the collegium system that is prevalent as of now. The provision of appointment of judges district is provided in Article 233. Article 233B. What is the minimum age requirement for becoming a district judge? No judge at all, no age bar. The first High Court was set up in Calcutta in the year 1862. Answer B. Odisha High Court was established on 26 July 1950. Consider the following state: Gujarat High Court, Manipur, in 1960. Himachal Pradesh 1971. Odisha High Court 1948. It is 2013. 1971. So first Odisha 4132. 4132 C. 4132. Alright, guys, we have already completed judiciary in this part, and with the next class we shall be talking about the state executive, and also before that we shall definitely mention, okay, so in the next class we shall be discussing the state executive, governor, chief minister and other dignitaries. Also we shall discuss first all other questions on this body, but before that we shall have a brief look at judicial review and judicial activism and PIL case. We have a brief note on that. Then I think we shall proceed with the governor. Okay, so let me say you a good day for all of you. Get prepared because the exam is overdue. It is awaiting. You have to take care of yourself and get prepared for the upcoming examinations. We are trying our best to provide you the best material and best coaching to all of you for your bright future. Okay, thank you very much to all of you for watching and give your constructive comments in this regard. Thank you all.
Sir,